All right, so we're going to go live. All right, we are going live now. Just give it a second, and I'm just going to hold up my thing until I see that we're on. Just give me a moment. All right. Okay. We are here. Welcome, everybody, to another installment of the Queen's Podcast Labs Learning Series for content creators. My name is Joseph Cohen. I'm an associate professor of sociology at Queen's College in the City University of New York. And today I'm very happy to have as a guest Steve Vondran from Vondran Legal. Mr. Vondran is a specialist in law that applies to content creators and is a great person to talk to. You know, legal concerns are probably the last thing content creators are thinking about when they start their enterprises. They might see the law as a peripheral issue that they can safely ignore. But anyone who's ever gotten into serious trouble knows that this is a big mistake. Even the slightest misstep can cause you huge headaches, maybe press you to take down your catalog and all sorts of things. So there's a lot to focus on, and we're grateful to have a knowledgeable guest. So thank you, Mr. Vondran, for joining us today.
Thank you, Joe. I really appreciate your show, and thanks for having me on. Looking forward to it today.
But before we begin, just to introduce you to our audience, you want to tell us a little bit about yourself and maybe your legal work and your creative work, because you're also a creator.
Yeah, that's great. Yes, I have been a lawyer since 2004, so about 17 years now. And our firm practices in what I like to think of as a niche area and a growing area of intellectual property law, internet law. And we handle quite a few infringement cases dealing with movie infringements, photo infringements, you name it, architectural infringement, jewelry infringement, all kinds of things that you see on the internet, counterfeit goods, all kinds of things. So we handle this, well, we usually represent the defendants or the person being charged. So we have a lot of knowledge about how to try to stay out of trouble.
So today we're going to talk about intellectual property law and libel law, two big concerns. Maybe we'll start with intellectual property law and copyright law. For those of us who are listening who don't know anything about this field, what is intellectual property law? What is copyright?
Well, so look at it this way. You have the broad heading of intellectual property. Underneath that, you're going to have copyrights, which is one form of intellectual property. You're going to have patents. Those are your inventions. Copyright are your books and your music and anything creative that you put, your podcasts are copyrightable. Your websites, blogs, copyrightable. Your patents are your inventions. Then you have trademarks. That's your name. That's the name Queen's Podcast. You get a trademark on that. And then you have what's also known as trade secrets. Now, trade secrets is like what I'll tell people is the Kentucky Fried Chicken secret recipe. Okay, you don't go get a patent on that. Otherwise, everyone would know about it. You can't copyright it. So you can get a trademark on KFC, but you need to have a trade secret to keep things secret so nobody knows the secret formula. So that's basically your four forms of intellectual property. Some people will throw in there a fifth, a right of publicity, using your name and your image and your likeness, which is kind of your talent and what you've honed and crafted for yourself. So you could call it that as well. That's not kind of somewhere in between.
So copyright happens when you create something original and then you have a right to it. Is that how it works?
Yeah, that's exactly how it works. So the phrase is anything that's an original work of authorship, which is fixed in a tangible medium of expression, automatically gets copyright protection, whether or not you go and actually register it with the United States Copyright Office. So an original work of authorship fixed in a tangible medium of expression. So that can be a photo, that can be a painting, that can be a movie, that can be software code, that can be jewelry. There's a company that sues a lot of people for jewelry infringement. Okay, that can be architectural plans. So it's such a wide range of what falls under the heading of copyright, which is why I do it and which is why I really enjoy it.
I heard that you can just, if you sketch a paper on a napkin, then in a way that's your own piece of art. Is it really that simple? You don't have to register it with a government office or anything like that?
It's exactly right. And I sometimes will tell parents that I talk to on the phone, I'll say, it's your child could draw a flower on a piece of paper that is copyrighted. So it's an automatic copyright protection. Now, if you want to go the next step, pay the $65 and have it registered and make sure nobody else can do that, then you have that option.
What are some of the common misconceptions that creators have about copyright? You hear all sorts of stuff from other podcasters or social media creators. Some of it sounds true, some of it sounds unlikely. In your career, what have you heard are the big misconceptions that people have?
Well, I'll tell you, on the side of defending people, let's just take photo infringement, for example. People will say, well, I found it on the internet. I just thought you could just use it because it was on Google or it was a free image. Or nowadays we have the Creative Commons licenses, and somebody may say it's free to use. But you have to make sure you give the link or the attribution, as we call it. So there's misconceptions. I would say that if you find it on the internet, it's free to use. There's also misconceptions in the area of fair use. Some people will say, I do fair use reviews of documentary films as well. And somebody will say, well, I only use 30 seconds of the song. And I say, well, picture it if it was your 30 seconds of your song. How would you be okay with that? So there's misconceptions. Well, what if I just use it for 5 seconds? And there's a fair use balancing test and whatnot. But so those are some of the common ones that I think I run up to quite a bit.
Can you explain fair use? Because I have heard podcasters say, oh, I can put any music at the beginning of my podcast as long as it's less than 15 seconds or 20 seconds for fair use. Is that what fair use means?
Well, that is the concept of fair use. And, what we do is fair use opinion letters, because the filmmakers need to go and get insurance so they can distribute their films. So we look at each clip. It could be a sound clip, music clip, it could be a sound effect, it could be a news clip, but there's no hard and fast rule that if you use 3 seconds, for example, that you're good. The way I tell people, there's so many sites out there nowadays where you can get some good music, but everybody wants the one, so to go they want the Led Zeppelin or something. You got to be careful when you're using clips from big companies, Universal and Sony and all these big music companies. You got to be careful. And there's sites that make it so cheap and inexpensive. I use those cheap sites. It's the way to go. You don't have to worry about it. But no, you need to keep those as short as possible. And ideally, fair use is commenting or criticizing, not just borrowing somebody's creative sounds and saying, hey, I really like that. It would be great in my podcast. Taking a video clip and commenting on it. You see that a lot on TikTok nowadays, where creators will do TikTok, or they'll be looking at a video and commenting on the video. So that's how they get away with fair use on that.
So if you can show copywritten material on your medium if you're showing it as part of making a point to the audience, is that what you mean?
That's correct. Yeah, that's exactly what you're looking to do. Comment, criticism, scholarly and research purposes. And the rule that I tell people is minimum necessary. And of course, I can't give legal advice on the show, but the minimum necessary. Take just what you need to show what you're showing, what you're talking about. Bring it in, bring it out. Okay, so that's the best I can tell you to try to qualify for fair use. Show it, comment on it, get it out of there.
But of course, always ask your own lawyer for the specifics of your situation. Go. So can you describe some interesting copyright infringement cases that you've encountered, or common ones that we can know about so we know to avoid them?
Well, like I said, we do a lot of photo infringement, so I'm not going to go too much into that. Movies. There are quite a few lawsuits that we handle from a company called Strike 3 Holdings. They sue for sharing their movies through BitTorrent. Okay, so a lot of people with technical skills, they know how to, it's like the Napster used to be, and you can download software, you can download, and people do. We also handle the software download cases, but somebody's getting a hacked copy of Microsoft or something. So, but so I always tell people I never miss my opportunity. Tell friends not to share movies on BitTorrent through the file share and the swarm and all that. That can lead to literally some, could cost you $5,000, $10,000, $20,000. So that's not something you want to be involved in. But other than that, we have, like I said, we've had infringement of architectural plans. We've been involved in jewelry cases where somebody says you're selling my jewelry on Etsy. That's my design on Etsy, things like that. And we've handled so many different types of cases, and publicity cases where somebody's using your image for an advertisement on their website or, in a brochure, write a publicity cases. So just a lot of different things. And unfortunately, most of the things I do I have to keep confidential. But
sure.
Broadly speaking, those are the types of things that we would get involved in.
So we have some interesting questions in the chat box here on Zoom. And if you're watching on YouTube, feel free to use the chat box there. Here's a question from Jason Tuga. In an educational podcast, how much latitude is there for including sound clips from film, TV, or music if the episode is discussing the clips?
Oh, that's what I like. I mean, I think that's a great question. And that's exactly what we're talking about. When you're commenting on the clip or using it, if I'm going to use the clip, I'm going to be commenting on it. That I can promise you. Sometimes I tell my filmmakers, you have this clip of a historical video of it. Talk about it. Say something about that clip. If you're using a music, maybe transform it. Anything that is transformed into something new. One of the things that, for an example, is like that Obama poster that said hope on it. Somebody took a photo, made it something new. Okay, so they gave new meaning to the photo, things like that. But now you're transforming and creating a new piece of work. But yeah, the educational uses are going to get a little more leeway. Documentary films are going to get more leeway. Now, things that are purely commercial products, that's when you have to be careful. This is when the plaintiffs come out and say, how much money did you make on that? Well, you made $5,000. Well, that's part of my stuff in there. That's where problems can arise. But yeah, educational commentary and transformation.
Ryan Sperry writes, I suppose parody counts as fair use, like TikTok lip sync videos and things like that.
Yeah, parody is a very interesting area of the law. We say it's like shooting at the king. You better not miss. Yeah. And so the point with parody is you have to be making fun of what you're using. So if you're using a picture of Kermit the Frog, you can't use Kermit the Frog to comment on something else that would be considered satire. Does not get the protection. You're just using that to be funny. If what you need to do is poke fun at Kermit the Frog, you have to be poking fun at the original to get the parody protection. That's a distinction many people miss. But yes, parody is going to, parody. I don't know if you're old enough to remember Weird Al Yankovic. I don't know if he used to do all the songs and the funny songs, but he would always go to the artist first and ask, can I use your song? Do you mind? Here's the lyrics. Here's what it's all in good fun. And they would normally say yes. But if they didn't, I understand it. He said, I won't do it. But he still could have probably qualified for a parody.
Jason writes, I once had a roommate who got sued for downloading music from Napster. I think he had to pay $10,000. What are the penalties like for these types of infringement?
Yeah, well, that's interesting. The music industry was one of the first to get into these cases, and it was through the recording industry, RIAA, and they came in and they were hitting people hard because they saw it as a big threat to their business model. And, they didn't realize that they were going to have to sell songs for 99 cents one day, but yeah, they went after people. The penalties were really high at the beginning, but the copyright law itself is, and the one reason I'm engaged in copyright law is that the penalties can be as low as $750 for an infringement. That could be one song you download, you could owe $750, but if it's a registered copyright, then you got to pay their attorney fees too. So that 750 photo On the low end, plus the attorney fees, now you got a $2,000-3,000 case. And if you have 3 or 4 or 5 songs, now you have 10 easy, if you have 100 songs, 1,000 songs, you're in big trouble. But so, and there's provisions where it could be as low as 200 if it's an innocent infringement, but it can go up as high as 150,000 per infringement. That's what's so crazy about the law. So, for example, if you go into a movie theater and you broadcast the movie and you're broadcasting it live, and that you could face $150,000 on something like that. It's a serious event. Now there you have the FBI warning symbol, which usually wakes a lot of people up to prevent that. But in many other places, a lot of people don't realize that things are copyrighted.
Are there any other questions on copyright and intellectual property just before we turn to libel? Any questions or comments for Mr. Vondran? All right. All right, so then let's shift gears for a second and talk about libel. What's libel?
Okay, so let's go back to our heading again. Okay, we have a heading called defamation. I think most people know what defamation is. It's a false statement of fact that injures somebody's reputation. Okay, now there's 2 types of defamation. We have slander, which is talking, oral, slandering somebody in public. You're the worst person I've ever seen. You're a liar, cheat, and a criminal. That's slander. Libel, on the other side, is written. So you have defamation, slander spoken, libel is written. Now, the way I always remember that is libel is like a label. Labels are things. You stick them on things. It's a written. That's how I always remember that, so I don't get confused. So on the internet, of course, we're talking about libel, which is written defamatory language, false statements of facts about a person that's publicated, has to be publicated, and which tends to cause one shame, ridicule, hatred, to be shunned and avoided, that kind of thing. So, and we know what those things are. A common one nowadays is people going onto Yelp, that attorney's a fraud. And you say, well, now you're talking about this in his profession. Be careful, you better have it backed up. Okay, so, but that's what libel is. It's written defamatory content. And on the internet, it stays around forever these days. So that's why people are so up in arms about it.
So in a podcast, you'd worry about slander because it's spoken. Is that what you mean?
Well, yeah, that would be spoken. Ultimately, that is, recorded and archived and everything else. But either way you look at it, it's a defamation. And some people just sue for defamation in general, just call it defamation.
So wait, let's say I don't like The Rock's new movie and I'm like, The Rock sucks. Can The Rock sue me for saying that he sucks publicly?
Well, that's a very good, again, can't give legal advice, but you're alluding
right.
You're alluding to is opinion, okay? We all have a constitutional right to our opinions, as long as they're realistic opinions and not just trying to. But if you have an opinion, let's say you're a political columnist or a game reviewer, yeah, you have your right to review and you have your right to say something sucks. And people even bought domain names that said, Walmart sucks, let's say. And so they're allowed to do that because it's a form of commentary and criticism. So in this area of law, we don't want to chill free speech is what we say. We want a free, open, robust marketplace of ideas. And so, yes, you get your opinion as long as it's not a false statement of fact, which tends to defame somebody.
So it's when it's not true that you start running into you can say anything you want so long as it's true, but it's when it's false that it's a problem.
Yeah, that's correct. And as long as it's true. Now, what I always say, maybe a lot of people don't do this, but I'm a lawyer, and when I think about posting things, I ask myself, can I back this up? If somebody called me on it, and I saved my notes, I put it in a folder. If anybody ever calls me on that, says that's not true, I say, well, I have the evidence here. It is true. But truth is a defense to defamation. Okay. If you can show that it's true, there is a thing in the law of most states. I would assume most states have now. I'll speak to California directly. anti-slap laws is what we have now. So if somebody is telling the truth and you're saying, oh, that really upsets me, I'm going to sue them for defamation or slander or libel, whatever, there is a motion you can file called an anti-slap motion. It's a lawsuit against strategic public participation, and you can get your attorney fees if you can show, I am just speaking my mind, Judge. I am just giving my fair, honest opinion. I'm sorry this person doesn't like it. You can actually cut off that defamation lawsuit and pick up your own attorney fees. So we have a counterbalance in the law to protect against that kind of thing.
Are there any sort of, I'm not asking about personal cases, but maybe something that, you know, all lawyers learn about in law school, like some type of defamation case that sort of illustrates, you know, how you could get into trouble and how judges would rule. Is there, I'm trying to think, maybe that's a terrible question actually, because it's just so broad. But do you have any favorite defamation cases where you're like, oh, I love this one, it's a classic?
Well, yes, the classic case would be New York Times versus Sullivan. And the reason why that's a classic case is it shows and it stands for the proposition that public figures, those who hold themselves out to the public, they have a higher standard of proof if they want to prevail in a defamation case. You say, well, why is that? Why would, for example, Donald Trump went around suing everyone? Well, he's got a higher standard of proof because he's a public official, a public figure. They have to prove what's called actual malice in order to prevail. And that is that the author of the article had knowledge of the falsity and a reckless disregard of the truth. So it's a high standard. And that's because we want, again, robust debate on public figures, people who thrust themselves into debates, public officials. And so, again, this is all to help the marketplace of ideas and communication.
So you have, sorry, go on.
That was my favorite case.
So you have to be extra careful when you're publicly speaking about not famous people or not public figures?
Yes, against what we would just call a private individual as opposed to a public figure. Yes, you would have a lower standard of proof. Like I said, all you need to show it's a false statement of fact, tends to injure the reputation, published to a third party. And if they're a public figure, you need to add on the actual malice. So you have one extra thing that you have to prove as the plaintiff.
And I gathered from what you said earlier that the best defense for libel is to have your notes and make sure that when you say something about someone, you had a reason to believe it was true. Yeah. And that's sort of how you defend yourself against that.
Absolutely. Yeah. And there's also like media perils insurance and things you can buy just in case. Some people like to get the it's called media perils. It will protect you for inadvertent false statements that, you know, when you, as a podcaster, you're talking 24/7, and if you're missing an edit, you get the chance to edit it, I assume, but not all. But in case you say something on a live stream and you go, man, I can't take that back. You know, you can get insurance to cover.
I'm writing that down. That's a great piece of information.
No charge.
Thank you very much. Are there any questions on defamation speech or any comments in the chat box, or would you like to do it live? Barbara says, so what's the definition of a public figure? Like, who counts as a public figure?
Well, I would say, I don't know if there's an exact precise definition, but let's put it this way. Anybody you would find in a newspaper, anybody you would find in a magazine, anybody that thrusts themselves into a public controversy. Now that could be, maybe there's a lost child, they can't find the child, and the mom comes forth and she's running remember who was the one, her daughter in Aruba?
Natalie Holloway.
Yeah, Natalie Holloway. She came out and she was all over the place. Now, I would say she has thrust herself into the controversy. So even though she's a private figure, she's now sort of elevated herself to a public figure. opening up more comments, criticism, what not. So, but yeah, so I wouldn't say there's a hard and fast rule, but magazines and newspapers, you see them on TV, sports stars, actors, actresses, people you would know. And again, these are the things lawyers fight about. We go to court and yes, she is. No, she's not. Yes, she is. We got this case law. We got that case law. So those are the things we wrangle about in court.
Yeah, that's one thing I didn't realize about the legal system until I got older and came into contact with it. There's not as many hard definitions of things. It comes down to what a judge or a jury will say, won't it? Like you can't really, it's a guess. Is that true?
Well, it can be. The cases that actually go to court, when I say court, go to trial, those are the ones where usually we're talking splitting hairs. Factual hairs, legal hairs. We're really trying to figure something out. There may not be a lot of precedent on it. And so those are the ones that you see actually going to trial. Other than that, 90-something% of all civil cases settle. And usually we have precedent. Usually we can figure out a fair, honest definition of what something means. But, they say if you put 10 lawyers in a room and ask them, what's the definition of battery, you're going to get 10 different answers.
Yeah.
It's
you guys are like us. It's as frustrating as professors. Are professors public figures if they publish and if they're in the media, or how does that argument often?
That's a fair question. Now there's things known as limited public figures. It gets into, if you ever read the jury instructions for defamation, you can pull them up in California. There's about this many different definitions, depending if you're this, if you're this, if you're this, if you're this, if you're this. So, but yeah, I would say that on a campus, a professor might be very well known and, in a type of position where that may qualify. So yeah, that may be something you have to look up your local case law.
A comment from Ryan Sperry. Seems like there's a fine line for opinions. Can't I just have an opinion that someone's a fraud or engage in conspiracy theories or things like that?
Yeah, you can. But again, this is where you have to be careful. You have to be careful who you're picking on, how you're doing it. Now, if you say, I bought something on Amazon or let's say I bought something on eBay and in my opinion, this seller is a fraud. Okay, so if you couch it like that, you're in a much better situation. Yes, you do have an opinion. You can believe someone's a fraud. Now, if you're saying that the seller is a power seller and says, this isn't cool, and I got lots of money, so maybe I want to see if we can test the waters on this and send them a letter, send them a takedown letter, make them take it down or retract it. Maybe I'll file a lawsuit. I don't know. So you always want to use common sense. Court is not the place you want to spend your time. You want to spend your time creating, building your channels. That's where you want to spend your time. So be very careful about that. But yes, certainly you have a right to your opinion.
If you find yourself in trouble, you get a lawyer's letter in the email or something, what should you do?
Well, now I'm not biased here or anything, but I think you should call a lawyer. Most lawyers will give you a free consultation. The good ones, but find out where you stand, where you're at. I see a lot of cases, especially in photo infringement. Somebody will get a letter from this company from Canada. They'll look at it. It seems a little scammy, or they're scared. One that they just chuck at the wayside, and then 2 weeks later, they have a law firm. Now this letter looks real. Now the fees have gone up because they had to spend it. So I always say, when you first get sign of a legal trouble, a subpoena, anything like that, just call your friendly neighborhood lawyer and make sure they're in your practice area and ask for a free consultation. They will usually give it to you. If you have to pay a fee, a small fee would not hurt you either, but find out where you stand before you take your next act. Don't call people. Don't start telling everyone everything. Now you've got witnesses that you're creating. So just take it easy, call your friendly attorney and see where you stand.
Don't emote your legal problems on social media or things like that. I suppose.
Yeah. I'm not saying there might not come a time where we call it the law of the press. There is a time when you would use the press to benefit you, but yeah, it's these things, once they're posted, you got potential for libel, and just it's hard to get these things down. They get archived forever in the Wayback Machine, and it's just think before you post.
All right. Are there any other questions for Mr. Vondran? Do you want to give some information about, Ryan? Ryan Sperry has a question. Go ahead, Ryan.
Yeah, I just have one question about, I was typing it now as you're going to end, but how about the role of the FCC? Is there any role for them in any of this with like broadcast media or streaming? Do they ever get involved in protecting people's rights to say things, or do you know any cases where they've gotten involved in maybe suing or protecting, or do they just stay out of it until they need to?
Well, FCC, Federal Communications Commission, and the FTC, the Federal Trade Commission, they're really the two watchdogs that are looking for things that are wrong, pirate radio, false and deceptive advertising, false and deceptive statements for the FTC. But they're usually looking for bigger companies as opposed to small podcasters. I'm not, never say never, but they're looking for big companies that are making major violations that they can make a public thing about so that they educate everybody else. And usually there's enforcement actions and there's fines involved in those kinds of things. But yeah, they're the watchdogs of the FCC, the media, the airways, drone, or FAAs with the drones, and FTC, just like I said, just consumer protection, things like that. But yeah, they're out. But in my experience, usually the bigger companies. So I don't deal much with them, but they're out there if you're a bigger player doing something wrong.
A question on the chat. I'm curious about music sampling. If a musician uses a sample to make something new, like Warhol, why isn't it fair use?
Well, there's a lot of different case law on that right now, and federal courts are broken up into different districts and circuits, and so there's 11 circuits. So you got to check your jurisdiction very closely, not only where you live, but where the artist lives, and make sure, because some courts in California are now saying, sorry, you can't do that. I don't care if it's real short, the artist made it and you're using it. You're using this ingredient in your song. And other jurisdictions may be a little more relaxed on the whole thing. But you got to understand, Ninth Circuit, where I practice, we got entertainment, we got technology companies, we got radio, TV, we got it all. So they're very protective of the artists and creators in the west side of the United States. But yeah, I mean, there may be some, but that's one thing I won't say, yeah, just go for it, you'll be fine.
I get the sense from your answers that the law is a lot like science, in that people from the outside think all the rules are super clear. And from the inside, you're like, I don't know, it's what everybody agrees to or not, and you can't tell. Is that really how it works? It's like the law isn't extremely clear with clear lines. You sort of have to know the rules and hope that a judge or a jury would side with you. Is that how it works?
Yeah, that is. I mean, I guess a lot of it is the gray area. I remember when I first went to law school, they said they would hammer this the first year. They would say, you guys, this is not like medical school. There's not a right answer. There's not a right and a wrong. It's not the hemoglobin or the white blood cells. There's no right answers. There's arguments. There's law. Words all have multiple definitions. Put in one sentence, you have multiple words with multiple definitions, and then put in a paragraph, put in the case law you have over here, put in the case law you have over here. Oh, by the way, how does the judge feel about these kinds of things? Has the judge ruled on this before? So it's argument. When you hear a lawyer say, I'm going to argue, we're going to argue, we're arguing, not to be mean, but we're making legal arguments based on the fact and based on the law, and we're trying to persuade the judge that we're right. And so, yes, there's quite a bit of room for creativity in the practice of law, even though it seems like, but yeah, it's a great question.
Oh, Theo has a question. How is Disney able to keep renewing Mickey Mouse? It's been like 75 years, he writes.
Well, you have good lobbyists that pay a lot of money, and when they need something done, and in that case, Mickey Mouse, I forget, maybe 10, 15 years ago, it was coming up for to go into the public domain. Of course, you can't have that, too much merchandise sales. So they lobby Congress and they get an extension. I think it was the Beverly Song Act. I can't remember, but yeah, they got an extension on it, and that's how you do it.
So I guess the answer is be a major media company that can influence Congress.
Have friends on a hill somewhere. That's right.
Jason Tugal writes, it sounds like the gray areas are in your favor if you have a lot of money and good lawyers.
Well, he's getting to a good point. There's an old saying that we used to have, or at least not me, but I was good friends with a criminal lawyer, and he said, "How much justice can you afford?"
Right.
And innocent or guilty, innocent till proven broke.
Yeah.
So, yeah, unfortunately, yes, there is an element that if you have a lot of money, you can push people around in court. But the other side is our law understands that we do have provisions and ways for you to recover your attorney fees in certain circumstances. But yes, in litigation, I would much rather have a big deep pocket than a couple $100 for sure.
Colby Corley writes, if someone is an artist, do you know what the process is of copywriting your own work, your own artwork? So I think she's at, go ahead.
Yeah, there's a copyright office. It's now it's uscopyright.gov, and you just go there. You register for an account. It's very simple to do. I don't believe there's a charge. You put the details of your art in there. You're going to upload a sample at the end, and you're going to say who the artist is, who has the rights, who do you talk to if somebody wants to license it from you, and you pay a $65 fee. It's pretty simple.
Barbara asks, what percentage of cases are settled out of court? How often do things get to court? Is it rare or common?
Well, a lot of things get to court. So lawsuits flying is very common, but lawsuits actually going to trial by jury, if I had to guess, I would say the old rule of thumb is about 98-99% of cases settle before there's a trial. Quite a bit.
All right. Well, I think we're ending the amount of time that you very generously gave to us. Thank you. I just wanted to, before we go, if people want to know about your firm, you also have a podcast that I've listened to, the Vondran Legal Hour. Are you still podcasting?
Yeah, I do. Well, I do that from time to time. That's more of a search engine marketing thing for me. Yeah. Build out my website, but the site I like and the site I put my time into is attorneystevevideos.com. That takes you to my YouTube channel. Okay. And I've got 32,000, getting close to 33,000 subscribers. So nice. If any of y'all want to go hit that button, that would be great.
But smash that like and subscribe.
Smash it and give me a thumbs up, thumbs down. I don't care. But yeah, no, that's my site. And I have over about 650 videos. So lots of legal topics, lots of media related, IP related, copyright related, all kinds of trademarks, a lot of stuff on there. I even have one, how to do a trademark without a lawyer. So yeah, check those out. Lots of good stuff there.
I recommend them. I've learned a lot from I learned from your podcasting mostly. I'm a little bit of a podcast, so I haven't checked out your YouTube, but I will. But thank you for putting out those resources and being generous, with the public. It's really great. Oh, one more time, the website. We're being asked. What's the website again? I'll put it in the chat box.
Yeah, it's attorneystevevideos.com.
And I'll put that in the chat boxes. That was Stephen Vondran from Vondran Legal, an intellectual property attorney in California who specializes in a lot of issues related to content creators and a content creator himself. Thank you very much, Mr. Vondran, for joining us today.
Y'all at the top.
All right, I'm going to end the live stream. All right, we'll just give it 10